Good afternoon. Welcome to today's panel discussion, closing out the third annual Americans for Prosperity Foundation's Sunshine Week Symposium. My name is Ryan Mulvey. I'm Policy Counsel at AFPF, and I also am honored to serve as the president of the American Society of Access Professionals. I will be moderating today's conversation. Before we begin, I'd like to briefly introduce AFPF as well as our panelists, whose names and reputations, however, I am sure are already well known to our attendees and to those who will be watching this video after the fact. For over 20 years, Americans for Prosperity Foundation has educated and trained citizens to be advocates for a free and prosperous society and to fight for real change at the local, state, and federal levels. AFPF has a strong interest in open government and transparency. Our policy experts and attorneys work to improve the federal FOIA, state-level public access statutes, and related records management laws, such as the Federal Records Act and the Presidential Records Act. AFPF has been hosting a Sunshine Week Symposium now for the past 3 years. And the goal of these symposia has always been to bring together a diversity of views on government transparency, the shortcomings of our current legal regime, and solutions for a more open future. We have 5 panelists today whose essays have been published over the course of the week. I will post the link to the landing page where you can read all of those if you have not yet had a chance to do so. I'll introduce them in their speaking order, and then we'll jump right in. Full bios are online on our symposium landing page. I've asked each of the panelists to speak about their essay, and if they wish to respond to the other essays as well. And then we'll have some time for open discussion and questions and answers. David Coulier is an associate professor at the University of Arizona School of Journalism. He is also the incoming director of the Brechner Freedom of Information Project at the University of Florida, former president of the National Freedom of Information Coalition, and co-author of The Art of Access: Strategies for Acquiring Public Records. Ann Weissman is an outside litigation counsel for nonprofit organizations and individuals seeking to bring greater accountability to the federal government. Previously, she served as chief counsel and chief FOIA counsel for CREW, Citizens for Responsibility and Ethics in Washington, as well as executive director of Campaign for Accountability. Before entering the nonprofit arena, Ann served in the federal government at the FCC and DOJ, and she is an inductee in the FOIA Hall of Fame. Lauren Harper is Director of Public Policy and Open Government Affairs at the National Security Archive. She has authored or co-authored 10 of the archive's government-wide FOIA audits, including 2022's U.S. National Archives Budget 30-year Flatline and 2021's Still Interested Letters and Insult to Injury of long-ignored FOIA requests. She also writes regularly for the archive's blog, Unredacted, on a wide range of FOIA and national security issues. Bernard Bell is professor of law and Herbert Hannock Scholar at Rutgers Law School at its Newark campus. He teaches constitutional law and administrative law, among other subjects. Professor Bell's scholarly articles have appeared in several journals. He's a frequent blogger on the Notice and Comment blog hosted by the Yale Journal on Regulation. And prior to entering the academy, he was an AUSA in the Southern District of New York. And finally, Jason Barron is professor of the practice at the University of Maryland College of Information Studies. Jason previously served as a trial attorney and senior counsel at the Justice Department and as the first appointed director of litigation at the National Archives and Records Administration. He currently serves on the 2022 to 2024 FOIA Advisory Committee to the Archivist. He's a frequent media contributor on record-keeping controversies and has appeared in numerous media outlets. And I would add that I believe, Professor Coulier, you're also currently on the FOIA Advisory Committee. And as we discussed at the beginning, Lauren Harper is now going to be serving on the committee as well. So we have all the best and brightest, as it were, of the FOIA world here speaking on our panel. So once again, welcome. And Professor Coulier, the floor is yours.
Well, thanks. And I apologize in advance. I got to head
I
out.
think you're muted.
Oh, is it working? Okay. So sorry, I apologize in advance. I got to head out in about 40 minutes to teach a class. So, but I really appreciate the opportunity to chat with y'all, and I really enjoyed reading the essays. Just spot on and really, really cool. So, I was just going, since I am a professor, I can't help myself but show a PowerPoint. So I don't know if it would be possible to make me a co-host to share. Oh, there it is. All right. And I'm just going to run through this really quickly because, of course, folks can see the essay and details of what I'm talking about. And so, I've kind of been on a kick the past year or two in strengthening our public record laws in the country because, our challenge is this secrecy that's increasing, and we can look beyond just the anecdotes, right? I mean, we hear all around the country of the runaround that requesters sometimes feel they're getting from agencies at all levels of government, local, state, and federal, at the silence in responses. In fact, I keep hearing requesters saying more and more they're having to sue just because they don't even get a response. And so we're seeing more of that. And it's not just the anecdotes. I mean, this morning I just kind of culled through the Office of Information policy data and threw it in Excel and threw these together. And so we know that more and more FOIA requests are being submitted in the country, right? And this is just, this isn't even current. I've heard the latest numbers for last year is 930,000 or something like that. So they continue to increase, as do the backlogs. And this is, these poor agencies are swamped and they're not given the resources they need. And as a result, we're seeing some negative ramifications for the system. So the percentage of times that requesters are given a full grant of the records they asked for keeps dropping. Look at that. It keeps coming down to 2010. And the use of the denial of we have no records responsive to your request is kind of on an upward trajectory. That seems to be a thing. And we could talk maybe about why that is. I think Jason might have some ideas of why that is. And, I even looked at MuckRock data, and this is actual success in getting federal FOIA requests handled. And the success rate is steadily declining. 10 years ago, half the time you'd get what you asked for. Now it's down to 18%. And that is as straight a line as you can get, just about. And so something's going on. And of course, appeals are going up. More people are challenging these denials. And then the next step, they're suing. And so we're seeing all the increase in litigation. There's the track data, the FOIA project out of Syracuse University. That really shows the increase in lawsuits. And of course, that results in more money for the government. They have to defend these lawsuits, spend more money on attorneys and whatnot. So, that's not good for taxpayers. It's not good for the government. It's not good for the citizens. So we have this problem, right? And why do we care? Well, I think I'm speaking to the choir here. I don't really need to go into the reasons why this is important. For every dollar spent on public records-based journalism, in this case, society benefits $287. That's a huge return on investment. This is important. This matters. So we have this problem. Can we fix it? How do we fix it? I think we can. And so last year, we had a subcommittee in the Federal FOIA Advisory Committee look at how we can add a little oomph to the law. And we wouldn't be the first country to do so. About 80 countries have some sort of enforcement mechanism in their national FOIA laws. Mexico's a great example of that, an independent commission that can resolve these disputes quickly and cheaply, which helps requesters and agencies. Connecticut's been doing this since 1975. And now New Jersey, Pennsylvania has a great Office of Open Records. So there's some models that we can look at. And so how do we apply this? Right now we have OGIS, which is a great outfit for mediating disputes, an ombudsman, but no enforcement power. So do we add enforcement power to OGIS, or do we create another entity and let OGIS continue to be the ombuds? Or do we create something else? So in our report, we came up with 6 recommendations. And whether it's OGIS or some new entity, we borrowed from what seems to be working elsewhere in the world and in the States, and that is binding authority. I mean, it can't just be a suggestion. It's not going to be useful if it's just a hope. I think any entity should have the ability to look at records in camera. How can you make a decision if you don't see the records? Extra weight to their decision should be afforded by the courts if it goes to court next. Such an entity should have a direct line item budget and further ways of creating independence. So there aren't, the director's not fired by the White House or by someone else. Certainly more money's necessary to make this happen. OGIS has about a dozen staffers. It's the least staffed mediation entity in the world. I mean, they're even looking at states, it's not staffed sufficiently. So it's going to require some resources, and we need to study that. We need to study the ramifications of these ideas, right? And so I'll put in the chat that report that I referred to, and so people can look it up themselves. It's a 33-page report that goes through all the research that's on this topic going back decades. We talked to 40 experts on this topic all around the world and in the US, and we lay out the data, and we lay out the reasoning, as well as other ideas that might be considered. So next step, we got to really study this. So we're following up on it on the committee, and hopefully we can get perhaps a member of Congress to say, yeah, we need to invest in a study, a feasibility study, to see how this would work, see what the unintended consequences are, see if we can make this happen. And then at that point, hopefully we can make some changes that'll do some good. So that's my spiel, sticking to it.
Thank you, Professor. We appreciate your essay and joining us. And I understand you'll have to probably ditch out before Q&A. But nevertheless, thank you for joining us. All right. Next up is Ann Weissman.
Thank you, Ryan, and it's an honor to be on such a distinguished panel as this. And I'm sure that my remarks will echo a lot of the sentiments of David's. But let me start in this way. Throughout my career, I've been very honored to have the opportunity to meet with delegations from emerging democracies. And one of the things that they have focused on is often they have new FOIA laws, their own FOIA in their country. And they really perceive these laws as a critical component of their democracy. And for many of them, it's a very novel concept. The idea that citizens can actually find out what their government is up to. They have a legal ability, a legal mechanism. And it's really left me thinking about our law, which of course we all say, and I truly believe, is core as well to our democracy. I mean, we've seen the events of the last number of years, I think have really illustrated how critical transparency and accountability are if we want to keep our democracy. And yet I can't help thinking from my experience that somehow we've gone off the rails. And for me, one of the biggest problems that I can pinpoint is delay. I think delay is one of the fundamental ways that is interfering with the FOIA working as Congress intended. And there are many causes, many factors I think are responsible for that delay. I think for one thing, FOIA historically has been, I think, underfunded. A lot of the data that David just showed us in his charts, I think, he didn't have one on funding, I don't think. But it's only gotten worse, as you can imagine, because as the number of FOIA requests have gone up, as the litigation has gone up, there has not been a corresponding or relative increase in funding. And so agencies find themselves in a situation, they don't usually have a line item budget for FOIA to begin with. It's not a priority at agencies. They don't, even though it's a statutory command, it is not treated the same way the Social Security Administration would treat its obligation to administer a benefits program. FOIA is a statute that I think agencies think will only get them in trouble for the most part. So it's dramatically underfunded. And what that results in are delays that are sort of unimaginable. And in my piece that I wrote, I pointed out two examples. One of them is something that just happened in a case I brought recently on behalf of a nonprofit. We got an estimate from the agency of several 100,000 potentially responsive records. They proposed a processing rate of 500 pages per month. Now, math is not my forte, but I double and triple checked this. It worked out to, if they were correct in their number of responsive records, it would take 43 years. I mean, it's on its face, it's absurd. And yet this is what the government agency proposed to the court. So clearly, 43-year delay is not what Congress intended. And how can that possibly serve the interests that FOIA was enacted to serve? And then I pointed out another case where we were, through litigation that took us all the way through the Court of Appeals in DC, we were eventually able to get a document. It was the OLC memo that had been prepared for Barr on the sufficiency of Special Counsel Mueller's evidence on obstruction of justice. And it was a hotly contested litigation. The government had argued that, in fact, that memo was essentially an assessment of whether or not they should bring a charge against the president. When we got the memo, it was clear that was not what was going on. Instead, it was really all about crafting a characterization of the evidence that would best serve President Trump. But we got it. However, at the time we got it, both President Trump and former Attorney General Barr had left office, which meant that that true accountability that you're looking at the FOIA for just wasn't possible. So we have critical underfunding at the agency level that I think has resulted in delays that really are, in my view, intolerable. And as I think someone alluded to, all too often now, I litigate. When we go to court, we are not litigating about the merits of a particular exemption. We go to court to get a processing schedule. And this is a problem on many levels, including the fact that it essentially negates the Open America stay, which was the process, the relief, the escape valve, if you will, that Congress set up when an agency is overwhelmed and can't meet its FOIA obligations. So Congress said, yeah, you can, push out those obligations in time, but you have to make a certain showing. And that showing includes, what resources you have. It includes that you have asked for additional resources, but not received them. And a number of other factors that Congress thought were important. So it wasn't an automatic sort of stay of your obligations. I bring this up because now the way litigation happens, you file a lawsuit, the government files its answer, and then the first thing the district court judge does is issue an order requiring the parties to meet and file a report that advises the court on, a processing schedule and, what the rate will be, et cetera. And so this completely bypasses the Open America process that Congress set up to deal with the kind of delays that we're looking at. And it allows an agency to make a proposal that may not be tied to a serious effort by that agency to deal with its backlog. So this, again, has compounded the problem. And judges seem to accept at face value the proposals that agencies are making. And when I have pushed back, one of the responses I've heard from judges is, well, if I order a higher processing rate here, I'm going to have to do that in all of the cases before me. And they are just reluctant to push the agencies to do something that the agencies claim they can't do. So the net effect of all this is that agencies don't feel any serious consequences from not meeting the FOIA's timetable. And not only do they not face serious consequences, but all too often they face a judiciary that is sympathetic to them and not willing to impose any serious consequences. And I think one of the most egregious examples of that in my book has been the comments of a district court judge here in DC, who has really taken aim and suggested the problem lies not with agencies, not with underfunding, but with the requesters, and has suggested that nonprofit requesters in particular are motivated by the ability to recover attorney's fees. Well, I've been in the nonprofit world for some time now, and I can tell you that the number of cases in which I have recovered fees compared to the number of cases I have brought, there's a huge gap there. It's only in a very small number. That is not what is motivating nonprofits. But what I find so troubling about that, going back to my opening point, is it's a failure to recognize or acknowledge that the FOIA is a really important statute to our democracy. How can you be so dismissive of people who are trying, and entities who are trying to use that statute to advance our democracy? And yet, I think that is a view that I am hearing, at least from one judge, and I hope it doesn't represent a trend. So, not to be entirely pessimistic, so let me close with this. What can we do? I've been part of groups and individuals who have been advocating for FOIA reform for a long time now. We've had some modest success, but we keep fighting. I do think that Congress has to give more money to this. I think until agencies have better funding, we will not solve the problem. And I think, David, a lot of the solutions or the suggestions that the advisory came up with are very good ones. But again, without money, I think this is an intractable problem. I think there has to be teeth in the statute. It cannot be that an agency can blow off again and again and again the agency guidelines, the FOIA's statutory guidelines, and suffer no consequences. I don't know if I'm reluctant to make those monetary consequences because I think that just adds to an agency's problem. They're underfunded, and then if they have to devote more funding towards penalties for non-compliance. So I think we really need to think about what makes sense. Maybe they actually will lose the ability to assert exemptions, certainly exemptions that are what I would call discretionary. Obviously they can't lose the ability to protect classified information, but maybe they lose the ability to assert an exemption like Exemption 5. I think this calls for really serious consideration, because if the status quo remains, we can talk about theoretically, conceptually, what a great statute the FOIA is, how it serves these extraordinarily laudable goals. but it will be academic only at some point. The reality of the FOIA now, I think, has been that it essentially, we're in a broken system. And it pains me to have to characterize the statute that way. I mean, I've spent decades working with the statute, litigating it, trying to make it better. But I really believe we are at this crossroads that if we don't wrestle with the really serious problems we have in implementing the statute, you know, it is just going to be another great idea that never lived up to its potential. So I will stop there.
Thank you, Anne. Next up is Lauren Harper.
Hi, everyone. Can you hear me? Okay, I'm so glad to be here, Ryan and James. Thank you for organizing this. And it's so wonderful to talk with folks about FOIA. I'd like to respond to a couple things that David and Anne brought up, in part because it's impossible not to when you work and live and breathe this stuff, and also because I know David has to jump. I will say very quickly, as a representative of a nonprofit who goes to court fairly regularly, recouping attorney's fees is not the goal. It's to win the release of historically significant information, at least for us. But I wanted to touch on a few of the key things that David brought up. He brought a lot of information from the Department of Justice's Office of Information Policy that are intended to give us kind of more or less an objective view of what's going on with FOIA across the government. And I say intended because one of the things that I have found as someone who really enjoys going through OIP's data year after year is that it's pretty far from objective. You know, with all the stats that OIP collects about FOIA's performance and administration across the government, it has given the government above a 90% success rate for the past 5, 6, 7 years that I've been tracking it. I think this year it was 92-point-something% success rate for releasing information. It's just really remarkable and mind-boggling and frustrating to see OIP, which is the component of the DOJ that's in charge of encouraging, not enforcing, but encouraging government-wide FOIA compliance, kind of continue to portray FOIA as working so successfully, even though all of us on this side know that not to be the case. One of the things that OIP does to kind of get this A grade for a FOIA release across the government is to get this tally. It excludes requests that are deemed improper, whether or not they're actually improper, whether that's voluminous or that kind of thing. I think a better success rate probably hovers around 50. But of course, you know, you have to keep in mind if you're getting a partial release, that doesn't mean you're necessarily getting a substantive portion of that document. You could just be getting a line or two. So some of the issues that we're dealing with here have to do with, I think, DOJ's interpretation of its role. And one of the biggest tests that I think DOJ is going to have coming up has to do with the decommissioning of FOIA Online, which, as a lot of folks here may be familiar with, is the EPA's FOIA portal. It's being decommissioned September 30th of this year. And so that puts a lot of pressure on the national FOIA portal, which was mandated in 2016 to be a single website where anybody could go to file a FOIA request with any agency across the government. Our most recent audit that the National Security Archive conducted for this year showed that key agencies are still missing, and we're not anywhere near close to the goal of having a national FOIA portal. So DOJ and OMB are in charge of ensuring this portal's success. And the proof will really, I think, be in the pudding of what happens with FOIA Online's decommissioning. There's a lot of ways to improve FOIA.gov. In fact, the Biden administration made that one of its commitments to its National Action Plan for the Open Government Partnership. We suggested a bunch of ways to improve FOIA.gov. For example, having a universal FOIA library, something like that would make processing of a lot of FOIA requests hopefully unnecessary, and I think would really encourage common sense declassification decisions. It would also help encourage agencies to kind of meet the proactive posting requirements for the FOIA. And then I just wanted to hit really quickly, we've been talking a little bit about OGIS being the most poorly funded, mediation component in the FOIA, in the kind of global FOIA world. NARA's 2023 performance budget shows that OGIS, its budget is not going up in any terms of real dollars. It hasn't for quite a long time, and certainly for it to fulfill a more substantive function, it needs more money. And perhaps more troublingly, NARA's IT budget is just 0.2% of the government-wide IT budget. And this is an agency that is in charge of the vast swaths of these federal records. Not only that, we also have next year's requirement that agencies be giving and accessioning their records to NARA in electronic format. And there's just, in my opinion, not the infrastructure there. And we're also not seeing the funding really being put in place that will require this all to be successful. So that's just my reaction to the things that Anne and Dave were saying. But now I'd like to transition a little bit to the work that my organization does, the National Security Archive. We are primarily concerned with historical records. So these are records 25 years and older that have to do with American foreign policy decisions and national security decisions. You know, it would be remiss of me to say that we haven't had a lot of successes using the FOIA to obtain historical, but also timely records. For example, we've gotten a lot of records released on relations with Russia as it emerged after the end of the Cold War, including the rise of Putin. We've been able to win the release of a lot of nuclear proliferation documents, which I'd argue are incredibly significant now that Russia has pulled out of the New START agreement. We've also won the release of a lot of documents on America's wars, both in terms of miscalculation on you know, agency and administration planning parts, but also attempts to kind of hide these blunders. For example, one of the archive projects that's near and dear to my heart is the Iraq documentation project. And one of the records that we were able to get released through the FOIA was a PowerPoint slide that was prepared for General Tommy Franks under the codename Polo Step. And we got this release through the FOIA in 2007. And what it basically showed was that CENTCOM really believed that the US would only have 5,000 troops left in Iraq as of December 2006. And so documents like this really help the public inform debate about things like invasion force and unrealistic assumptions about the war in Iraq. There's another really good example of kind of what FOIA can get released and how that can promote our national debate about some of these things. And this is Craig Whitlock's The Afghanistan Papers for the Washington Post. Our organization worked with Craig Whitlock on this. And basically what this was FOIA released records on lesson learned interviews conducted by the Special Inspector General on Afghanistan Reconstruction, combined with the records that we got released, which were Donald Rumsfeld's memos. And taken together, they showed a pattern of misleading the public for really decades. And so these have all been really important, I think, to kind of discussing Americans' most critical foreign policy decisions. But while we've had victories, I think the bigger thing that I'm left with is the obstacles that remain, including for documents that are historical 25 years or older. And this isn't just something that, you know, those in the nonprofit world, research historians are saying. This is something that has been continually repeated, perhaps most notably by the current Director of National Intelligence, Avril Haines, who's spoken at length about how withholding too much information on foreign policy and national security is in of itself a national security risk. She's identified also the cyber world, as the cyber space, as an area where the compartmentalizing of information is a real national security risk. But the opposite of that is the inverse, is that she's emphasized that declassification of information on Ukraine, for example, help promote national security and foreign policy objectives. I think the same could be said possibly of the declassification by the State Department of Information on the Chinese spy balloon. So this is all to say that declassification really can and is in the public good and the public interest, but overclassification remains a perennial and increasing problem. And I think a great example of just how bad it is is looking at the State Department's publication of its Foreign Relations of the United States series, which it is statutorily required to publish as a thorough, accurate, and reliable record of U.S. foreign policy no later than 30 years after the events that they document. The State Department's Office of the Historian has called this first series one of the largest transparency projects in certainly in the States, but it is one that is dogged by overclassification within other components of the U.S. federal government, particularly the Defense Department. And the State Department's Historical Advisory Committee has repeatedly called out the Defense Department for hampering states' ability to release these critical records that it's statutorily required to do. On top of that, we know that the Defense Department, like so many agencies, is always trying to have greater authority to classify information. And we know that they're currently trying to find a way to withhold more records on foreign policy material. So it's things like this that we need to continually be on guard against. And to avoid kind of ending this on too much of a pessimistic note, I think there really are fixes to this. For example, one of the things that's been proposed that I think would be very effective is something like a drop dead date for certain records, perhaps 25 years or older, to make sure that they're actually automatically declassified, which is something that's in the current executive order, and giving the National Declassification Center at NARA the authority to declassify information that's subject to automatically declassification and not having to go back to consult with the originating agencies. And I think things like this would really help move the government writ large to a more common sense declassification footing, especially as it deals with more and more of these records, particularly electronically, being created every day. So I'll leave it at that and say thanks again for having me.
Thank you, Lauren. It's our pleasure to have you. All right, our next speaker is Professor Bernard Bell.
Yeah, hi. Thank you for the invitation to participate in this panel. It's been wonderful, and I'm honored to be invited. And particularly thank you to Ron and James. I want to focus on a particular transformational impact of American political culture and the legal landscape that FOIA, I think to some extent, has wrought. And particularly I'm focusing on the invigoration of public interest groups. So traditionally, many interest groups have coalesced around economic interests, particularly business groups and labor groups. So if you were educated in the 1950s and 1970s in political science, you probably have heard a lot about interest group theory and how it was difficult for public interest groups to form and compete with concentrated economic interests in the legislative and administrative arenas. And yet today we see there are a wide range of public interest groups, and obviously many of my fellow panelists have represented or litigated on behalf of such groups in the FOIA space. As is evident, again, from this panel presentation, many of those public interest groups use FOIA extensively. And perhaps this goes without saying, but they use it for several purposes. One is to publicize regulatory failures or government inefficiencies or improprieties. But two others, maybe a little less obvious. The second would be to lobby either administrative agencies or members of Congress for policy changes. And the third thing that many public interest groups do is they have to turn to litigation, right? Because they may not be successful in their lobbying efforts, and there may be legal constraints on agencies or legal obligations on agencies that they are not meeting, and FOIA helps public interest groups identify those and give such groups a factual basis for engaging in such litigation. So litigation may be aimed at preventing agencies from exceeding their authority, or it may be aimed at agencies failing to faithfully protect beneficiaries of the applicable statutory regime. And in fact, regulatory failures often tend to be the latter, right? In some ways, the under-regulation, the under-protection of groups and people who are expected to be protected by the regulatory regime, unless you have, the phenomenon of capture of administrative agencies. In any event, FOIA is absolutely critical to allow public interest groups to serve their function and do what they do. And in my essay, I mentioned several meritorious FOIA requests that have helped disclose important information regarding what the government is up to. I think I mentioned 7 requests, but I could choose among hundreds of requests that have provided or disclosed important information. So we've talked a little bit about just Judge Trevor McFadden. I mean, I guess his ears should be burning because we were talking about him a lot in this session. But in the essay, I mentioned his criticism, which is one of the most, I think, recent prominent criticism of the quality and nature of FOIA requests made by nonprofit agencies. And his allegation is namely that nonprofits are repetitive filers of overly broad requests designed to dig up dirt on agency policies and the people behind them so as to frustrate agencies' pursuit of their legitimate missions. And of course, there's much to be said about this. And in the essay, I critique that claim, and I make a further critique of that in the notice and comment blog post, which I reference in my essay for this panel. So I guess I'm trying to keep it short. So in short, public interest groups' successful use of the tools made available by FOIA to gain, publicize, and use government information invigorates their efforts to influence government policy, and I think is a profound change in the landscape of American politics. Let me pivot to mention something that I didn't talk about in my essay, but I think is really relevant to the excellent lead essay, which Ryan Mulvey and James Valvo have written. And I guess they're being unduly modest and not pointing out that they too have written an essay for this presentation. So the point I want to talk about in particular is the affirmative disclosure provisions of what was initially known as the Administrative Procedure Act, particularly Section 3 of the Administrative Procedure Act, which is 5 U.S.C. 552. And FOIA essentially revises that section 552A. 552. Right? But in enacting FOIA, Congress expanded the pre-existing affirmative disclosure provisions in important ways. So the affirmative disclosure obligations that are in particular subsection A of 552, which tend to get less attention than the provisions with regard to reactive disclosure, require disclosure of such things as agency adjudicatory decisions, rules, and guidance, right? Agency guidance, without the need for a FOIA request. And a lot of people have suggested that one of the ways to make transparency better, or the transparency system better, is to have more proactive or affirmative disclosure by the government. So this is fully consistent with that. So you might say that the subsection A, which is under discussed often, really focuses on agency legal materials. So this is all a lead up to my noting that I'm a consultant along with 4 others on a project entitled Disclosure of Agency Legal Materials for the Administrative Conference of the United States, otherwise known as ACUS, which does a lot of work with regard to administrative issues and administrative procedure and process that involve cross-agency issues, and really is a really important, although little noticed, agency. So in particular, this Disclosure of Agency Legal Materials project seeks to expand Section 552A to encompass a greater range of agency legal materials, thus making them subject to affirmative disclosure. So we can kind of talk about what that expansion is, but I just want to note right now that that's one of the things that this project, or we as consultants at least, are suggesting in our draft report with regard to this project. And I should also note that we avoid tinkering with any of the FOIA exemptions in our report. And those FOIA exemptions apply to, I think the general wisdom is, although some people may disagree, that those exemptions apply to the affirmative disclosure provisions of 552A. Our project also suggests legislative changes with regard to how agency legal materials are made available so that they can be more easily found on agency websites, because having material up on an agency website doesn't do a lot of good if people can't find it. We also propose a provision that would make the Section 553A obligations enforceable. And there's a circuit split on this question of how you enforce these affirmative obligations. So I think it's the Ninth and the Second Circuit say, yes, of course, these affirmative obligations are enforceable, and we can order the agency to affirmatively publish such materials to the general public. There's a kind of odd DC Circuit opinion that says if someone requests records, or if someone sues to compel an agency to affirmatively disclose records that should be disclosed, affirmatively disclosed under Section 552A, the person seeking the order can get those records, that the person can essentially get an order that they're entitled to have the records disseminated to them, but not an order that the records have to be published on the agency website or made more generally available, which is kind of an odd holding. So we think it makes sense to have a proposal that resolves that dispute in favor of enforceability. So what's the status of this work? Well, our consultants group has submitted our draft report to ACUS, and there's an ACUS committee that's about to meet to craft recommendations for ACUS's adoption. So I think I'll put in the website the URL for the page, the ACUS page that has this particular project and has all the documents that have been created over the course of this project. The draft report being the latest one, but also comments submitted from everyone who submitted comments with regard to this project, and I think some minutes of meetings that our consultants group has had with various government officials. So with that, I want to close and, and basically say that I think that FOIA has made some transformational changes that have improved the workings of our political system, albeit, as many others have mentioned today, it has its problems. Oh, and I guess I was going to say one thing with regard to funding. So I think it's absolutely right that agencies are completely underfunded as far as responding to FOIA. And the great example of that is the FOIA Improvements Act of 2016, which added some affirmative disclosure provisions, added the foreseeable harm standard so that when an agency concludes that it can withhold records, it still has to nevertheless determine that disclosing the record would create a foreseeable harm of the type that the exemption was designed to prevent. If it doesn't conclude that, then it's supposed to release the records anyway. So that obviously costs money. And nevertheless, in the 2016 FOIA Improvement Act, Congress appropriated $0 to implementing these new requirements. I mean, I guess they had been episodically administratively required before, but now they were statutory requirements, and there's absolutely no funding added to meet those responsibilities. So with that, I'll turn it back over to you, Ronnie.
Thank you, Professor Bell. And last but not least, we have Professor Jason Barron. Jason, the floor is yours.
Thanks very much, Ryan. Thanks for inviting me. I really appreciate it. Appreciate being with my fellow subject matter experts on FOIA. In particular, I want to say that A.M. Weissman's absolutely right. The FOIA is broken because of the delays that requesters experience. And let me just say that we are in the second half of the chessboard. That's a term of art. Let me tell you a parable. There was a great king. The king was offered by the inventor of chess, the game. King was enamored with it. The inventor said to the king, here's what I want. I want 1 grain of wheat or rice be placed on the first square of the chessboard, and then 2 grains on the second square, 4 grains on the third, and so on. And the king was baffled by that, a small price for a wonderful game. He said, great. Treasurer said, fine. But when you play that game from 1 grain of rice to on the first square, it comes out that there are 18 quintillion grains of rice on the board in the 64th square. And when the king learned of this, and he said, he thought for a while, he did the only rational thing that a king could do. He had the inventor killed. Of course, today, with the same demand, probably the king would say to the inventor, go file a lawsuit, and it would probably be just as painful. Here's the object lesson for 2023 and beyond, looking to the future. We are in a paradoxical world where the incredible growth of electronic records arguably has resulted in it being more difficult for FOIA requesters to access those records. The growth of government records is not necessarily exponential, but it is overwhelming nonetheless. There are 600 million presidential emails at the National Archives from Ronald Reagan to Donald Trump, comprising 3 billion pages of records. That, by the way, is just about the second half of the chessboard, which is 2 to the 32nd, which is 4 billion. How many are open to the public? Well, on the order of 1/10 of 1%. That means 99.9% of White House email is not accessible to the public. And there are reasons for that, mainly involved with PII, with personally identifiable information that the records are chock full of, and other personal information. And under the privacy rules that the National Archives has in regulations, those records won't be available for 75 years unless there are litigation or FOIA requests. How about the rest of the government? Well, with the capstone approach to email, instead of print to paper, email is archived in 250 components of the government. All email is saved for 7 years. Senior officials email permanently. That translates into tens or hundreds of millions of emails at large cabinet agencies. And NARA just has put out a bulletin that says that they want electronic messaging of various types to also be archived by Capstone. And that I think is a good thing, but it only increases the amount. And then we have the government being supposed to be under a mandate that keeps getting, the goalposts keep moving, but it's June 2024 now for under the latest OMB memo M2307, which says that the government has to manage, all agencies have to manage their records, temporary and permanent, in electronic form, and they need to send the permanent records to the National Archives. So there's a tsunami coming to the archives, but how do agencies search through these huge collections of records now? Well, they do keyword searching. And how do they filter those records? Well, that's mostly manual. And as Ann's pointed out, I mean, 43 years is absurd, but with the growing amounts that are there, over the next decade, that 43 years is going to be a really small amount of time from the estimates that are being brought forward in litigation. The legal community has known for 2 decades that keywords are inadequate. They're both under-inclusive and over-inclusive, and manual processes don't work when you're up at millions of records. But there are solutions, at least partial, to this mountainous problem. E-discovery lawyers know that machine learning software does a great job of expediting the process in litigation of finding responsive records. Something that would have 2 years of keyword searching where you just get hundreds of thousands of hits and you have to go through each one can be done in a week or weeks with kind of the low-hanging fruit gotten first. The most responsive documents in litigation are able to be reviewed. And in a FOIA case, that can result, if it's employed in the same way as e-discovery lawyers do it, that an interim release on the most responsive records, and then having the rest talked about in terms of agency burden. So there are solutions there. If anyone in the audience wants to type in technology assisted review or TAR, T-A-R, or predictive coding and e-discovery, you can see a wealth of information that's out there, but that hasn't reached the FOIA community in the way that it should. And more recently, so there's a search issue that I think can be partially solved through AI and machine learning to speed the process up. And then there is a filtering issue, which I admit is a harder problem because it has not been solved for all of the FOIA exemptions to have AI just applied and you can filter or segregate material. But there are steps that are known, and I've been involved in a project with the MITRE Corporation, and there are other commercial vendors that are certainly out there talking about being able to identify for exemption 6 for personal information for PII, as well as now exemption 5 for deliberative process material. So it's coming, but the search problem partially solved by AI. The filtering problem is still out there, but I think it will be partially solved in the coming years. I really think that machine learning is magical. It is, the fact is that it really does expedite a process of finding the most responsive records. And so I urge, I've said this to the Senate Homeland Security Government Affairs Committee when I was testifying with Ann last year, that they really need to put forward ideas, maybe an AI advisory committee. I certainly would hope that within government, the Chief FOIA Council and the Technology Committee and our own FOIA Advisory Committee push the ideas of better search techniques, because I do believe that if without them, the delays that we're experiencing are only going to get worse. So that's my piece. Thank you for allowing me to say it.
Thank you, Jason. All right, so we've had 2 questions come in, but before we get to those, I'd like to have a little time for open discussion, and if panelists want to react to what they've heard, to kind of get that started, I have a question or a prompt. Feel free to ignore it though if you don't want to. We've kind of hit on it already. The theme of this year's symposium was really to reflect, particularly after last year's symposium, which was about how FOIA is broken, was to focus on how FOIA has had that transformational impact. And just so everyone's aware, we told our contributors this year that the prompt was advisory more than obligatory, that we were interested in hearing anything they had to say. But I would like to talk about, I personally, as I reflected in my essay at the beginning of the week, I do think that we have had FOIA has had a huge impact culturally, certainly in the requester sphere. We may think that as a requester myself, I will say we may find FOIA frustrating at times, or the state of the case law is frustrating, but FOIA as a tool, as a promise of transparency is a powerful motivating reality. But I'm also reminded of something that was discussed at the December 2022 at the FOIA Advisory Committee meeting, where there was a panel and participated on, and myself as well, where we talked about the culture within government. And we can say that FOIA has had a huge impact more broadly in our political culture and in the minds of requesters and in the media. But how has FOIA been received within the government? Because I would agree that there are lack of funding, understaffing, but there's also the reality. I'm reminded a few years ago when the State Department was sending people to the FOIA office as a sort of punishment, because people didn't want to have to deal with FOIA. And that sort of cultural opposition to transparency within agencies, you can't fix that by fixing the statute or throwing more money at an agency. So how do we fix that? And let me give, not to answer my own question, but to give you an example that maybe can spur some answers. OIP, for the first time in quite a while, released substantive guidance that isn't about FOIA reports or something, right? Namely guidance on how to apply the foreseeable harm standard, which had been introduced with the 2016 amendments, but had gone with, really, in my experience, with DOJ trying to argue that it didn't actually do anything. So the fact that OIP took that position and now has to release guidance because it's lost in court so frequently that the standard does actually mean something. I mean, isn't that somewhat of a reflection of the need for cultural change within government? Thoughts? Feel free to just jump in, panelists.
Well, I'll give another example that I just learned of, which is DHS just put out guides. I think it was DHS just put out guidance about how to apply the requirement that your request reasonably described. And what was refreshing about the guidance was it basically said, you can't use that if they're asking for a large volume. And it was really kind of preaching caution on applying that standard, which, given how much energy we've had to put into it, what I think is really a make-weight issue, it was very, it was encouraging to see. So yes, I think your answer to your question maybe really does point the way, which is to change the culture. Agency officials, agency FOIA people, the agency in general, need to be better educated about what the FOIA is, what it isn't, and what it requires.
Yeah, I think there was also American Oversight just settled the case with the CDC. I think it was on a policy and practice claim. And they survived the motion to dismiss, but I think what the part of the settlement was is CDC had to help have American Oversight help them edit a notice that was emailed out to all the FOIA staff telling them about this issue, about request validity and what a reasonable request is. And the fact that you're going to get a terabyte of data in response to your search doesn't mean the request isn't described. That speaks to a different aspect of processing. Lauren next, and then Professor Bell.
Yeah, I would just say, FOIA is fixable, and declassification is really possible at kind of an astonishing level when there is top-down enthusiasm for it, encouragement of it, and enforcement of it. And I think the best example that I can think of, at least in terms of the work that my organization does, is the Argentina Declassification Project back in 2019. This was an initiative to review something like almost 50,000 pages of highly sensitive documents on human rights abuses in South America. And we're talking records from the CIA, FBI, DOD, National Security Council, that initially the Obama administration, but then the Trump administration had promised to give the Argentine government. And so these were records that the archive had been, my organization, the National Security Archive, had been trying to get for years. But as soon as there was kind of this presidential directive that was overseen by the National Security Council, they were able to organize the release of almost 50,000 pages of documents that were released at something like a 97% declassification rate. And these have been used tangibly to help prosecute human rights abuses in Argentina and other places in South America. So I just want to reiterate that when there is this top-down enforcement and follow-up, and an adult in the room, like at the National Security Council in this instance, following up with agencies being like, have you done this? Justify this. Prove to me why this needs to be continue to be withheld. I mean, we can do remarkable things. So I think culture is just a really critical piece of this, and it's something that we can enact.
Professor Bell.
Yeah, I want to note something that you and James said in your essay, which was when FOIA was enacted in 1966. Virtually every agency came up with all sorts of reasons why this was a horrendous idea. And the legitimacy of attacking FOIA, I mean, lasted into the 80s. So Justice Scalia has this famous article about how FOIA is like the Taj Mahal of unintended consequences or something like that. And you don't hear those arguments anymore. I mean, it has now established itself, FOIA has, as just a part of the bedrock of accountability of American government. And it may have its problems, but that transformation actually is fairly significant. I mean, it's largely, I think, illegitimate, would be viewed as illegitimate for, government agency to say no, but FOIA is an absolutely terrible thing, and should be abolished. So I mean, maybe I'm playing the role of Pollyanna here, but that is actually something that's kind of worth celebrating and worth remarking on. And I mean, I have kind of my own theory, I guess, but and it's not unique to me, but I think part of maybe what changed with regard to FOIA was the fact that you began to have a cadre of professionals who were essentially public information professionals or FOIA professionals whose job it was to kind of efficiently deal with FOIA requests. And I think the Department of Justice kind of came up with programs to reward or honor people who did good jobs in working in that space and really trying to be responsive. And so I think you developed a cadre of professionals who, this is what they do, and they don't have that kind of automatic resistance. I think, depending on the presidential administration, particularly the Trump administration, I think you may sometimes have people, but I shouldn't use may. You do have people in higher levels of government who do view FOIA as some sort of danger, and they want to try to get around it as much as possible. They create these programs where now there's a political review on top of the review that's ordinarily done in responding to FOIA cases. And I think that then begins to create problems. That begins to undermine culture in the way that Lauren was just suggesting is problematic. So that's those are my points on this.
So really, it's really interesting. Can I respond to that really quickly?
Yes, please.
Yeah, I think, there's also been a certain acknowledgement, both within certain agencies, not all of them, but also at the policymaking level, that having a robust FOIA and declassification shop not only ensures that policymakers and agency officials have a better understanding of their own history and of what's gone on at the agency, it really helps shore up institutional memory at a lot of agencies. That's why, a decent amount of agencies have offices of the historians that play a big role in their declassification and FOIA efforts. And it's really just understood by a lot, like CIA has this, State Department has this, DOD has these kinds of shops, that these kind of releases that are not only declassified, but published in a way for the public and members of the agency to find, boosts the work that the agency is doing. I think the State Department and its FOIA library is a great example of that. So it's not just for the public, it's also for the agency's own functioning, I'd say. And I think that's also been significant.
Anne?
I wanted to weigh in on a different point. I wanted to pick up Jason's point about the utility of AI in this arena, because when I was talking about backlogs and the estimated time it would take to process, what's really contributing to those numbers are the limitations of the searches agencies do to find potentially responsive records. And those of us who are, in this arena every day experience all the time estimates that will go from the tens of thousands down to 1,000 or less. Why is it that at the end of the day, the actual number of documents that are responsive is so much smaller? And I take the point that it's due, I assume, largely to the limitations of the software, et cetera, that they're using. But of course, it's those initial estimates that they go into court with, and that gives them a processing rate that's not effective. It gives them a time limit to complete processing the request that's very unrealistic. So I really endorse the idea that we need to start pushing these practical solutions, because it's also an answer to the understaffing as well. Obviously, to the extent you can automate, you're no longer limited as much by the fact that you may have a very small FOIA staff. So I think the time problem in many respects is being driven by really inadequate abilities of agencies to do effective searches.
Jason?
Right, just picking up on that point, I think agencies need to be a lot more creative in engaging with FOIA requesters. Given the size, the volumes of these repositories, I am a big advocate of agencies divulging their keywords for a keyword search, and secondly, working iteratively with requesters. When I have filed 25 requests in the last couple of years about the Capstone program, in some cases, I've been able to have a conversation that went something like this. Go do your search, have 80,000 hits. I try to do a very narrow request with only a couple of people, that records officer and a time limited, whatever. Go out, 80,000 hits. Give me 100 documents that you've reviewed and let me see what you've done. And, applying foreseeable harm or not, or whatever. And then we can have a conversation as an interim response on a very small amount going forward. And usually, it may well be that we can refine a request based on that sample and work together. And I think there's a lack of creativity in lots of shops that just are not there. They're tried and true, just saying that these requests are not reasonably described without engaging. So I like to make that point as a member of the FOIA committee for this term, and I really believe in it.
Okay, I'm just going to add real quick. I think that there are two broad camps of agencies, right? They're the ones that do try to think creatively or are open to a suggestion like that when it comes from requesters. But I have encountered quite a few agencies that, well, you don't have a right to that under FOIA. So there's either that response, even when DOJ might be okay with exploring it as a compromise, or there's a, well, we don't know whether we want to do that because that might come back to burn us in the end, or say on a question of search adequacy. But otherwise, I endorse what you're saying, Jason. I agree. Professor Bell, and then Lauren, and I don't know if you still have your hand up or it's new. Yeah. Okay, Professor Bell.
Yeah, so I love Jason's point about artificial intelligence. I think that would really be a great advance. And I suspect that part of the problems agencies have is that their computer systems and their technology is not really up to date. So, you know, if they had technology that could do the AI, that could really simplify things, but that requires funding, and that's the thing that is often agencies are often short on. And I mean, the other comment I'd make is that just from looking at the cases, it's really astounding how many cases are adequacy of search cases, that, you know, the agency searched the wrong keywords, they didn't search enough keywords, those sorts of things. So that really is I would agree that that's really a major problem and a major area where some improvement would be extremely helpful.
I think another area, just picking up on what Jason was saying, that could stand improvement and should be feasible is uniformity in what agencies both believe they can do and actually do in terms of a search. One of the things I did a couple of years ago was I filed a similar FOIA request with every single government agency about their ability to search for an email. And the number of agencies who immediately came back and said, oh, I can't do that, forcing me to go in on an appeal and say, you have to talk to your IT shop to see if you could, and then have those agencies come back and say, oh my gosh, yes, I can do that. And then, you know, produce the records, was really illuminating. I mean, different agencies genuinely have different search capabilities when it comes to that kind of thing. But there also just seems to be a disconnect oftentimes in those conversations that are happening between the FOIA shop and the IT shop. And I think kind of getting that more, a closer conversation is key. Another thing is that one of the things that I noticed when I did our audit this year for Sunshine Week was I took a look at every agency's FOIA page. And one of the things that I thought that creative agencies did to both help their staff in responding to requests and to help requesters file better, more targeted requests in the first instance, because that's something that we should all be aiming to do, was posting, for example, a map of their major information systems and the kinds of documents that those stored and how they differ between components. And things like this, I think help requesters immeasurably and would also cut down on processing time. Because if I can narrow a request before I file it, I would like to try and do that. So when agencies kind of enable that, that's all to the good.
Communication. Yeah. Okay, as we're nearing the end, what I think I'd like to do is we had two questions that came in from Kevin Schmidt and Alex Howard, and let's combine them and maybe use them as an opportunity for each of the panelists to kind of give a departing note, if you will. So Kevin, about prospects for the future, right? That was the unifying theme in all these questions. So Kevin Schmidt had asked, how much movement has the panel seen in terms of movement off of email and into messaging systems or apps for record keeping and official business? Is FOIA prepared to deal with the transition? I suppose we could say, is FOIA nimble enough to keep up with radical technological developments? And Alex Howard asked, what are the prospects for reforming FOIA again in this Congress to address issues like the whole SCOTUS Blue in the statute with Argus Leader, a reference to exemption 4 there? What are the prospects for getting more funding for modernization and human capacity? And what will the sunset of FOIA Online mean for FOIA back to 2012 or forward? So with that, departing thoughts, answer those, just give your own response. It's all up to you. Whoever'd like to go first, please.
I'm happy to go first, and I'll try and kind of give a general answer to a lot of those components. And I'll just say that one of the things that I've experienced with FOIA is that agencies who want to do a good job and want to be creative tend to find ways to continue to do that. Do I think, generally speaking, FOIA is nimble enough, or agencies are all kind of willing to become more nimble? The answer is no. But I think what we have is a situation where agencies who want to do a good job and have that good kind of culture will find ways to continue to do so. And regarding FOIA online, you know, I to Alex's question, you know, I think the agencies that want to, for example, continue to post the records that have already been published in FOIA online and move those to their own FOIA libraries in the absence of a larger universal one will do that. But that in of itself is kind of one of the inherent problems, is kind of this lack of universality, and I would say stronger guidance and enforcement from DOJ and OMB on kind of these issues. But I think that's the key.
Excuse me, I'll jump in on especially on things like instant messaging. I think this has presented a huge problem for agencies, not just in the context of FOIA, but in record keeping generally. And not surprisingly, I think agencies have not been quick to develop a solution to this. So when it comes up in FOIA, the typical response that I get from an agency is that, well, we have a policy that says, you know, if you conduct agency business using one of these technologies, you're supposed to put a copy, you know, in your official email, in the agency official email or agency official file. And there's really it's very hard to penetrate that. I mean, I had a case where I specifically said, well, I want you to at least go back to these individuals and ask them to search their own email accounts, for example, because it comes up with agency officials using personal email accounts. The agency refused to do it, and the court refused to order them to do it. So I think it is a big problem. I know that Jason's given a lot of thought to ephemeral messaging too, you know, where the messages disappear. I mean, the government in general, my experience, and I've explored this also through record keeping statutes where we've sued the White House and agencies for not complying, is that agencies are woefully unprepared to keep pace with technology. And it has very real effects in the FOIA and in record keeping, and we're always playing catch up. And I would just say to Alex's question about FOIA reform, I think we find ourselves in a kind of somewhat dispiriting point. You know, Senator Leahy was a huge champion of FOIA reform, and he's retired. And it is not at all clear, to me anyway, that there is someone yet there to take its place. So I think the challenge, because one of the beauties of FOIA is that it's been there's been bipartisan support for FOIA reform. You know, Senators Cornyn, Senator Grassley, Senator Leahy. I mean, we were able to rely on them to some degree as you know, pretty reliable partners. We don't have that now. So I think it's a real open question. And I would just say on Argus Leader, actually efforts to address the Supreme Court decision in many respects ended up sadly derailing all FOIA reform. So we're at an uncertain time. And I think it's time for our community to kind of coalesce again and figure out where to go from here.
So I'll jump in. So I guess I'll make my concluding thought about Argus Leader and the foreseeable harm standard, because I think the judicial enforcement of a foreseeable harm standard, I think is just extremely important and may be a game changer. And I think in some ways it could be a game changer with regard to exemption 4, because while the Supreme Court's definition of the material that now fits within exemption 4 is quite broad, that the pre-existing case law, which was overturned, really focused on situations where releasing that information would be harmful. And so essentially some of the foreseeable harm, some of the post Argus Leader cases that apply the foreseeable harm standard begin to look a lot like some of the pre-FOIA cases, and looking at the same sorts of factors. So I guess it has yet to be seen how, with the judicial enforceability of the foreseeable harm standard, exemption 4 will fare, and it may end up looking a lot like the pre-Argus leader law, which just emphasizes the importance, I think, of that standard and of the judicial enforcement of that standard.
Professor Barron, the last word is yours.
Well, the question about new technologies, there's always some new technology and software development. And fundamentally, government personnel have to think of communications as records, as federal records, before you even ask the question about FOIA and access. And so agencies are only spotty in terms of recognizing ephemeral messaging as generating records. What I think one solution is for an agency to authorize one particular channel or 2 or 3 of ephemeral messaging and make sure to lock it down and capture that as an archive. And then people can use other means for personal communications. That's one way to go. Let me just say that the technology, as Ann said, will always outpace FOIA. FOIA traditionally, there's been a FOIA amendments every 10 years or so, more or less. So we can't expect that tomorrow or the next day or in this Congress, we're going to get legislation. And the technology is going to move. But we have to be smart and creative about, in the FOIA community, making points that agencies understand, and the agencies need to respond accordingly and be less cynical about litigation and FOIA requesters in terms of changing the culture. The last thing I'll say is a quote from William Gibson, which is, in some agencies, the future is already here, but it's just not evenly distributed throughout government. And so we can look for a day where more agencies are doing more with technological solutions like the ones that I proposed.
Thank you. I think that's a very fitting quote on which to end our conversation. And I want to thank, once again, all of the panelists for their essay submissions, again, which are, the link is in the chat. Please take a look at them if you haven't had a chance to read them yet. And thank you for your time and expertise in joining the panel discussion today. And thank you, attendees, for coming and sticking with us. I know we're right on time at 2:30 now, and I hope that you will meet us again next year for 2024's AFPF Sunshine Week Symposium. Have a good rest of the day. Thank you.